Since we have a quorum for a hearing, I am going to go forward. We won't go past the first opening statement until or unless one of the ranking members arrives. Today, we have a joint hearing on the politicizing procurement. Will President Obama's proposal curb free speech and hurt small business? The Oversight Committee's mission statement is, we exist to secure two fundamental principles. First, Americans have a right to know that the money Washington takes from them is well spent. And second, Americans deserve an efficient, effective government that works for them. Our duty on the Oversight and Government Reform Committee is to protect these rights. Our solemn responsibility is to hold government accountable to taxpayers, because taxpayers have a right to know what they get from their government. We will work tirelessly in partnership with citizen watchdogs to deliver the facts to the American people and bring genuine reform to the Federal bureaucracy. Today's hearing is about the Federal Government and its honest contracting proposals. I am glad to see that the Administration has agreed to testify before this joint hearing. There are many questions to be answered, and I have been concerned about the indifference and perhaps disdain of the Administration has shown at times toward congressional oversight. There is clear concern about a now well-circulated executive order that may have a chilling effect on political participation, free speech, based on partisan issues. The American people have a right to know what the government is doing and to impact, through its Congress, propose rules, regulations, statutes in this country. There is now bipartisan and bicameral alarm on Capitol Hill regarding the proposed executive order and its potential effects on politics in procurement. The concern about injecting politics into procurement is not new. It is not a Republican concern. It is not a Democratic concern. The acquisition and procurement laws and regulations are designed to preserve impartiality. We hold our very dedicated contractors to a high standard of seeking to get a level playing field, maintain fairness, and in fact obtain goods and services from the best sources on a decision made on price and quality. To protect the interest of U.S. taxpayers, contracts must be awarded on the merits of the proposed bid and not on political affiliations or political donations of the prospective contractors. Yet, under the President's proposed executive order, contractors would be required to disclose information about political contributions of some employees, and the information would be readily available to political appointees who are intimately involved in the decisions to award contracts. The risk that politics could play a role in the outcome of contracting and award decisions is too high. I believe the United States has some of the finest public servants in the Federal contracting officers. Day after day, they do the hard work of examining proposed bids, crunching the numbers, always seeking to get the best for the U.S. taxpayers. Notwithstanding an attempt to always do an analytical assessment, we will always have some contracts that are awarded on a no-bid or cost-plus basis. Particularly in these contracts, there is a high risk that the whim of a political appointee could in fact be swayed one way or the other based on a public record of contributions. During the Bush administration, when my friends on the other side of the aisle were in the majority, the committee spared no expense to hurl accusations of political bias in contracting process, and in the process, the names and reputations of some very good people were smeared. This committee is not going to take that approach, precisely because we want to protect procurement officers, contractors alike from the charge of political bias when we have this and other hearings. Meanwhile, I believe it is telling that the President's proposal says nothing about requiring similar disclosures from labor unions and liberal advocacy groups. Is the President not concerned about transparency on grantees, many of them trade unions themselves, or other groups that serve the country but do not fall under the general umbrella of corporate America? Nevertheless, we are here to examine what effects this proposed order will have on the contracting community. We must determine the cost, both to contractors and the U.S. taxpayers, if this proposal or one similar goes into effect. We must consider the efficiency of such a requirement. Will the President's political disclosure rule serve to delay the delivery of goods and services to the Federal Government? We have to ask if it is appropriate for government to require businesses to ask for information from employees that may be deeply personal and potentially detrimental to their career. Imagine your employer demanding to know, have you made donations to an organization that supports or opposes abortion? Do you have or have you given money to a group that advocates gay rights, gay and lesbian rights, or those that may have a religious objection? Can you imagine the effect of having to disclose that and then questioning whether your career is in jeopardy? Further, you could ask, are you supporting organizations that seek to expand union representatives of workers or seek to implement rights related to work laws? And finally, we must consider the constitutionality of this proposal. In fact, it appears that the order currently is not narrowly tailored to a compelling government interest. Although we will not ask questions as to the deliberative process here today, we do feel that as drafted, it's legitimate to ask what the effects might be on the Federal workforce, on employees that would be covered under this, and ultimately whether or not constitutionally this is ground we should go into. And with that, I recognize the distinguished ranking member for his opening statement. Mr. Cummings.